This is Mike Brady, and this is the presentation I made to the All-Party Parliamentary Group on Infant Feeding and Inequalities in the House of Commons on 17th of May 2016. This is about the International Code and action in the UK Parliament, not just in Westminster, but in the devolved authorities. I'm Mike Brady, I'm Campaigns and Networking Coordinator at Baby Milk Action. Baby Milk Action is the UK member of the International Baby Food Action Network, or IBFAN. This consists of over 270 civil society groups in more than 160 countries. IBFAN works for implementation of the International Code and resolutions and monitors company practices against these. The International Code of Marketing of Breast Milk Substitutes was adopted by the World Health Assembly in 1981 as a minimum requirement for all countries. Subsequent resolutions address changes in marketing practices and scientific knowledge and questions of interpretation. They have equal weight to the Code. The Code and the resolution should be read together. The World Health Assembly, of course, is made up of the world's health ministries. It adopted the Code and the resolutions, and these express the collective will of the highest global authority on health and carry substantial political and moral weight. This is from the new Code Status report, launched the week before my presentation in Geneva, been produced by the World Health Organization, UNICEF and IBFAN. The International Code and resolutions ban all forms of promotion of breast milk substitutes, feeding bottles and teats. In addition, labels cannot make nutritional and health claims or include idealizing images or text. Labels must include clear instructions on how to use the product and carry messages about the superiority of breastfeeding. Marketing staff must not seek direct or indirect contact with pregnant women or mothers of infants and young children. Health workers are responsible for advising parents. Information provided to health workers must be scientific and factual. The Code and resolutions also address issues such as gifts and sponsorship of health workers. For example, WHA 5832 states, ensure that financial support and other incentives for programs and health professionals working in infant and young child health do not create conflicts of interest. So sponsorship by formula companies, for example, is self-evidently a conflict of interest and inappropriate. It's very important to remember that the Code and the resolutions are there to protect all mothers and babies, regardless of how they feed. It's very clearly set out in the International Code and its aim. It says it's to contribute to the provision of safe and adequate nutrition for infants by the protection and promotion of breastfeeding and by ensuring the proper use of breast milk substitutes when these are necessary on the basis of adequate information and through appropriate marketing and distribution. We monitor the baby food industry in the UK against the Code and the resolutions and our narrower, weaker UK measures. And we produce monitoring reports like this on behalf of the Baby Feeding Law Group. The Baby Feeding Law Group consists of leading mother support groups and health professional bodies in the UK. The Code and resolutions not only have the moral weight of the World Health Assembly behind them, they also have status in international law through the Convention on the Rights of the Child. The UK is a signatory. Countries that are signatories are assessed periodically to see how well they are meeting their obligations. In its 2008 report, the UN Committee on the Rights of the Child expressed its concern that implementation of the International Code of Marketing of Breast Milk Substitutes continues to be inadequate and that aggressive promotion of breast milk substitutes remains common. It called on the government to implement fully the International Code of Marketing of Breast Milk Substitutes. This was not for the first time. In its 2002 concluding observations, it called on the government to reduce inequalities in health and access to health services, to promote breastfeeding and adopt the International Code for Marketing of Breast Milk Substitutes. The UK is being assessed again in 2016. In fact, this assessment began on the day I was making my presentation in the House of Commons, and we are still awaiting its recommendations. In this presentation, I'm going to look at the current situation with regard to the implementation of the Code and the resolutions and marketing practices, enforcement or lack of it, and the new EU Delegated Act and the proposed statutory instruments to give effect to these in the UK. The latest expert assessment of the UK and all other countries that are part of the World Health Organization comes in this new report launched on the 9th of May by WHO, UNICEF and IBFAN. Although over 70 countries have introduced most or many of the provisions of the Code and the resolutions, others have still got a long way to go. The UK is rated as having few provisions in law. The report recommends that countries that have not yet adopted legal measures are urged to do so, ensuring that all code provisions and recommendations contained in subsequent relevant WHO resolutions are incorporated. In addition, countries that have partial code-related legislation in place, such as the UK, should review and, where needed, amend and strengthen existing measures. It says that parliamentarians must be sensitised to the importance of code monitoring and enforcement and to their specific roles and support, including legislating for the code, budgetary review, approval and oversight, and political advocacy with constituents. So it's not enough to have the legislation. There should be an enforcement mechanism which is adequately funded, and parliamentarians can help move this forward, not only through action in Parliament, but through advocacy with relevant authorities, such as the Department of Health, the local government association, trading standards, and so on. Some further context: the Lancet breastfeeding series was published in January 2016, and this highlighted that the UK has the worst breastfeeding rates at 12 months in the world, at less than 0.5%. So there you see us highlighted in white in this world map. This report also talked of the lives that could be saved around the world through improved breastfeeding rates. 823,000 under 5 deaths could be prevented every year. This prompted some media reports to suggest that we needed to do more to persuade mothers to breastfeed, but this is to miss the point. It wasn't the message of the Lancet series. What it talked about was a whole range of measures to enable mothers to breastfeed. If we look at the situation in the UK, the National Infant Feeding Survey in 2005 found that around 9 in 10 mothers who breastfed for less than 6 weeks said that they would have liked to continue longer. The 2010 survey said of the mothers who had stopped breastfeeding by stage 3, that's 8 to 10 months old, over 3 in 5, 63%, said that they would have liked to have breastfed for longer. So let's not talk about persuading mothers to breastfeed or coercing mothers to breastfeed. Let's think about the mothers who say they wanted to breastfeed for longer, and think about how we can enable all mothers to breastfeed for as long as they want to. It will be difficult to know how the situation changes because the 2015 survey was cancelled by the government, even though the government cites the surveys going back to the 1950s in its submission to the UN Committee on the Rights of the Child. There it highlights that breastfeeding initiation rates, as shown by the surveys, have increased in recent years, but doesn't highlight the rapid fall-off in breastfeeding or the fact that it's cancelled the survey. So our first call to parliamentarians is to reinstate the National Infant Feeding Survey, so we have better access to data and can also understand the reasons that mothers are giving for their infant feeding decisions and the obstacles that they face. To empower mothers to breastfeed, action is needed in a range of areas, but we know what these are already because they're set out in the Global Strategy for Infant and Young Child Feeding. This was developed by the World Health Organization and UNICEF and endorsed by the World Health Assembly in 2002. IPAN has a project called the World Breastfeeding Trends Initiative, which assesses government's progress in implementing the actions set out in the global strategy. So our next call for parliamentary action is to address the gaps in the forthcoming WBTI assessment for the UK by considering the recommendations. One gap is poor implementation and enforcement of the code and resolutions. I want to look now at what this failing means in practice for parents and carers and health workers, and how they're targeted by the baby milk industry. One of the problems we have with our regulations is they treat infant formula and follow-on formula differently. So while infant formula promotion is prohibited, follow-on formula advertising and promotion is allowed. So you see adverts like this from Danone on peak time television which promote the Aptamil brand through the follow-on formula with the suggestion that babies fed on it will develop the strength, stamina and balance to become ballerinas and the mental capacity to become experts at calculus. We have brought complaints about these advertisements to the industry's self-regulatory body, the Advertising Standards Authority, but it has dismissed the complaints. Even though the companies claim that follow-on formula is not a breast milk substitute and so not covered by the regulations, it then promotes it with claims like this in the Danone advert, saying it's based on 40 years of breast milk research. WHO is very clear that follow-on formula is a breast milk substitute and comes within the scope of the code. Companies claim it's not, but then promote it as based on breast milk. Their advertising is also promoting the Aptamil brand used on the infant formula and the full range of products. There have been some efforts to use the regulations to stop this sort of cross-promotion. The guidance notes that accompany the infant formula and follow-on formula regulations that were adopted in 2007 and implemented in the 4 countries in the UK explain about this in paragraph 51. This says the specific terms infant formula and follow-on formula should be clearly featured on the packaging in a font size no smaller than the brand name. The colour scheme used for infant formula packaging should be clearly different to the colour scheme of follow-on formula packaging. Using different shades of the same colour is not acceptable, as it may lead to confusion. So this requirement for the products to be very clearly different in their labelling is aiming to stop cross-promotion and confusion. But as you can see, Danone has deliberately labelled its full range of products so they are virtually identical. So what's the status of these guidance notes? This is what it says. They come under the Department of Health, although they were originally developed by the Food Standards Agency. It says this guidance is aimed at all companies that manufacture, process, distribute, use, sell or import infant formula and follow-on formula, and those local authorities who are responsible for enforcing the legislation in this area. Legislation on infant formula and follow-on formula is implemented on a devolved basis. However, this guidance applies across the UK. So why do we see that Danone has totally ignored the guidance we've just read? And why has no action been taken by trading standards? Here's the problem. The guidance says the information set out in this document aims to provide non-statutory guidance on the rules which apply to infant formula and follow-on formula under these regulations. As it is non-statutory, companies and enforcement authorities ignore its provisions, whereas the interpretation could be tested in court. So we ask members of Parliament to encourage prosecutions of clear breaches of the regulations to build case law on interpretation. Members of Parliament have been signing an early day motion, number 1189, tabled by Alison Thewlis MP, calling for this action to be taken. So we would ask all MPs to look at this EDM and give it their support. Here's some other examples of the law being broken according to the interpretation set out in the guidance. It says on the requirement that labels do not have idealising text or images. The following are examples of representations which may be considered to idealise the use of infant formula should they feature on infant formula labelling. Pictures of infants, young children or carers, e.g. mothers or fathers. Graphics that represent nursing mothers and pregnant women. Here's the SMA label and you see these requirements being broken. There's a picture of a mother. The SMA logo itself also incorporates a stylised breastfeeding mother. The guidance on what the law means also says that these are prohibited. Pictures or text which imply that infant health, happiness or well-being, or the health, happiness and well-being of carers is associated with infant formula, and references to infants or carers' emotions. But we see Danone here using this heart symbol as part of its cow and gate logo. And it also has this teddy bear image on the label. Such images are specifically prohibited. The guidance notes goes on to explain the following are prohibited: baby or child-related subjects, e.g. toys, cots or young animals, and anthropomorphic characters, pictures and logos. Also prohibited are non-mandatory pictures or text which refers directly or indirectly to the ideal method of infant feeding. But what do we see on the Danone Aptamil? We see another bear image, and it also has this shield which is suggesting that Aptamil will protect. So we ask members of the APPG and other MPs to encourage prosecutions to build case law on what is idealising. Companies feel free to disregard the guidance that's coming from the Department of Health, but it's highly likely that a court would agree with this interpretation of the law and convict and sanction companies if a prosecution was brought, and that would certainly help in stopping these practices in the future. Unfortunately, in proposals the Department of Health has put forward for implementing the new EU delegated acts, it's looking to go in the opposite direction and decriminalise the labelling requirements, which I'll be talking about shortly. Here's another example of illegal promotion. Regulation 23 in the laws that have been adopted in the 4 countries of the UK is very clear that there should be no special displays, price reductions or any other promotional activity to induce the sale of an infant formula. Retailers such as Tesco have repeatedly broken this law, including this year. Tesco promoted Nestlé SMA infant formula across its chain with special displays and temporary price discounts. Baby Milk Action contacted Tesco's legal officer, who had promised in the past to stop such practices, but a promised response was not forthcoming. Violations continued for weeks. So again, we ask for parliamentary action to encourage prosecutions of repeat offenders. This case is specifically mentioned in the early day motion 1189 I just referred to. It's interesting to look at why Tesco was trying to clear these stocks of Nestlé's SMA formula. Nestlé has contacted health workers and explained that babies fed on the formula receive protein in excess of requirements. It's launching a new formula with what it calls protein profile closer to breast milk. But it's interesting to look back at how the existing formula was promoted. Here's an advertisement from before the time Nestlé owned the SMA, this to health workers, suggesting the formula has protein closer to breast milk. In fact, if you look at this, it seems the only difference between breast milk and SMA is that SMA does not have immune factors, but it ticks all the other lines in this presentation, unlike the other formulas which it's trying to suggest are inferior. Now, Nestlé claims that this formula now has excessive protein, but Tesco is not telling customers why it's discounting the formula and trying to clear it from its shelves. So there are certain activities that are illegal under our current regulations, but we also need to do more to bring these into line with the code and the resolutions. When the 2007 regulations were being developed, all health experts, including the government's Scientific Advisory Committee on Nutrition and the Trading Standards umbrella body, LACORS, said treat infant formula and follow-on formula the same. The new WHO UNICEF IBFAN report says countries with legislation should in particular ensure the inclusion of provisions that broaden the range of designated products under the scope of their legislation to include all milk products intended and marketed as suitable for feeding young children up to the age of 36 months. Now, the government has the opportunity to heed this call because the current regulations are going to be replaced. There are new regulations or delegated acts that are coming. These are implementing an EU regulation. Now, these have many of the same failings as the EU directives from which current UK legislation derives, including the follow-on formula loophole, and they allow advertising of infant formula in specialist publications. But there is scope for action. Firstly, the new delegated acts allow infant formula advertising unless member states prohibit it. They say, advertising of infant formula shall be restricted to publications specialising in baby care and scientific publications. Baby care publications are the perfect route for companies to reach parents with their misleading advertising and claims. However, it says specifically member states may further restrict or prohibit such advertising. So we ask for parliamentary action so that the countries of the UK prohibit such advertising of infant formula to go some way to implementing code provisions. Remember, advertising is not the same as information, and banning advertising does not prevent parents and carers getting independent information from health workers, nor does it prevent the companies selling the products. Note also that advertising to health workers is also misleading, as analysis from First Step Nutrition demonstrates, which we'll be talking about shortly. With regard to follow-on formula promotion, the new delegated acts do not contain a specific acknowledgement that member states can restrict the advertising of follow-on milks. However, the same was true under the current directives, and Luxembourg introduced such a ban without any legal challenge. So again, we would like to see parliamentary action to include follow-on formula, that is, breast milk substitutes marketed for use from 6 months of age, included in the scope of the products to which the ban on promotion applies. It has been well established that governments have the right to protect the health of their populations, and that right to protect health trumps trade considerations. Also note that aside from concerns over inappropriate promotion, follow-on milks are described by the World Health Organization and the National Health Service as unnecessary products. Moving on to the issue of so-called growing up milks. These are also unnecessary products and also come within the scope of the code. They are promoted with claims proven to be misleading. This is an advertisement for Nestlé's SMA sent out by ASDA, and in this case we did win at the Advertising Standards Authority. The ASA warned ASDA and Nestlé not to repeat this advertisement and told them not to state or imply that health could be affected by not consuming a product or to give rise to doubt the nutritional adequacy of a reference product. They give the impression you need these products to provide important nutrients, but they are not necessary. In fact, they are ripping parents off. The European Commission has stated that it will not be introducing regulations on the marketing of growing up milks. Under the principle of subsidiarity, the countries of the UK could, presumably, legislate to prohibit promotion of these products in line with the code. As parliamentary action, we ask, include so-called growing up milks and toddler milks, that is, breast milk substitutes marketed for use from 12 months of age to 3 years of age, in the scope of the products to which the ban on promotion applies. Whether included in the ban on promotion or not, health claims should not be allowed on labels or in marketing materials. Let's have a look at how this growing up milk promotion is being used in practice. This was a street stall from Nestlé promoting its SMA and Cerelac brands in the Leicester Belgrave Marla in August 2015. They were giving out free samples of the SMA toddler milk with money off coupons, but again this is branded exactly the same as the infant formula. There is no enforcement to stop this, and so our supporters were there handing out information telling the truth about Nestlé's marketing practices. Companies target pregnant women and new mothers, even though the law says that there should be no advertising of infant formula except in a scientific publication or for the purpose of trade prior to the retail stage. Companies are promoting their infant formula brand names through things like smartphone apps. Danone has this Aptamil Bear, which is a free gift if you sign up to its Mother and Baby Club. Once you're on one of its Mother and Baby Clubs, then you receive promotional information timed to the stages of the pregnancy and the development of the baby. So here there's complete peace of mind for the first 48 hours, advertising a cow and gate starter kit timed for just before the due date of the baby. So, we would like to see parliamentary action, prohibit direct and indirect contact between manufacturers and distributors of product within the scope of the code with pregnant women and mothers of infants and young children. The European Commission has never regulated the marketing of feeding bottles and teas. Under the subsidiarity principle, the countries of the UK could therefore legislate to prohibit promotion of these products in line with the code. As parliamentary action, include feeding bottles and teas in the scope of the products to which the ban on promotion applies. Remember that companies should not be promoting these products in any case. Article 11.3 of the International Code is addressed specifically to them, and it says, independently of any other measures taken for implementation of this code, manufacturers and distributors of products within the scope of this code should regard themselves as responsible for monitoring their marketing practices according to the principles and aim of this code and for taking steps to ensure that their conduct at every level conforms to them. So they should be doing it anyway. If companies did not spend a fortune on aggressive marketing, formula could be permanently cheaper for parents and carers who use it. Well, now we'll come on to the statutory instrument proposals. The Department of Health consulted in February 2016 on proposals for the statutory instrument to implement the EU delegated acts. There are serious concerns about these proposals. DH proposes decriminalising many of the provisions in the regulations, such as labelling requirements and the need to notify DH prior to launching new products. They're also suggesting moving to a system of improvement notices with the stated purpose of removing unnecessary rules and burdens on business. Companies do not need more time. They've been breaking labelling requirements since the first regulations were introduced in 1995. Improvement notices only make sense if their purpose is to protect the child's right to health, and they are intended to be a more flexible way to prompt faster action. To achieve this, they would need to be public, have deadlines attached, and be backed by criminal prosecutions if the deadline passes without the required action being taken. So we ask Members of Parliament to be very alert to the development of this statutory instrument even before it reaches Parliament, and oppose improvement notices unless they are part of a process of law enforcement and breaches lead to sanctions. The statutory instrument also provides an opportunity to enhance the status of the interpretation in the guidance notes. The guidance notes were developed by widespread consultation and have been very useful to groups monitoring marketing practices, even if they are ignored by companies and enforcement officers. So for parliamentary action, we would like to see this. Update the guidance notes to reflect the new EU delegated acts. The vast majority still applies, and enhance their status so they cannot simply be ignored by companies. I'd now like to look at the targeting of health workers. Nestlé entered the UK in 2012 when it took over SMA, and it's recruited a network of clinical representatives. Here's something from the job description in April 2015. It says their role is to work on the designated territory, visiting hospitals, doctors, health visitors and community midwives to develop key clinical relationships within your local health economies, leading to opportunities for the SMA brand and Nestlé Nutrition. You're to work with the NHS to develop long-term mutually beneficial relationships with key stakeholders and opinion leaders to support brand endorsement and strategically aligned education for healthcare professionals. So their entire purpose is to get brand endorsements and opportunities for Nestlé Nutrition. And one of the ways to do this is through education for healthcare professionals. As UNICEF Baby Friendly restricts access to hospital staff, companies hold events in nearby hotels, or they're offering international trips. This is an invitation to health workers for a 3-day trip to Nestlé in Switzerland in October 2016. If you look at the programme, you'll see that the middle day has an afternoon off and a vineyard tour and dinner. So what is the true purpose of this event? Also, when we look at the information that companies are providing to health workers, we find it is not scientific and factual. Independent information is available from organisations such as First Steps Nutrition, which assesses the claims that companies make and asks them for the research to substantiate it, so this can be critically appraised, and you can get its assessment and information on all the milks that are available on the UK market. There's also resources that are tailored for use by parents. And then we have the Local Infant Feeding Information Board, or LIFIB. This asks company reps to make their presentations to a multidisciplinary board, and this will assess this information and communicate anything that is necessary through its own bulletin. There is no need for the company reps to be going into hospitals and targeting health workers or trying to get them to go to nearby hotels or on jollies to Switzerland. The latest publication from First Steps Nutrition is called Scientific and Factual, and it's a review of breast milk substitute advertising to healthcare professionals, which finds that the research that is sometimes cited is laughable in its weakness or its bias. So please have a look at that on the First Steps Nutrition website. First Steps Nutrition suggested to members of the APPG that perhaps we should have a UK-wide infant milk committee, which collates and links together information on the composition, safety, cost and marketing of all infant milk products marketed for the age range 0 to 3 years, whose focus is consumer protection and which provides independent information to health workers to support commissioning and advice, which holds multinational companies to account if information they provide is not timely or scientifically adequate. So, summary of actions. To reinstate the National Infant Feeding Survey, address the gaps in implementing the global strategy for infant and young child feeding by considering the recommendations in the forthcoming WBTI assessment, Encourage prosecutions of clear breaches of the regulations to build case law on interpretation, such as in the areas of labelling, retail promotion, advertising, contact with the public, targeting of health workers. When it comes to the new EU delegated acts, opt to prohibit all advertising of infant formula. The right of EU member states to do so is explicitly stated in the delegated acts. Not so clear-cut, but also something that Parliament has the power to do, we believe, include the following as designated products. Follow-on formula, as Luxembourg has done without challenge. Milks for older babies, such as so-called growing-up milks. These are not covered by EU regulations. The same applies to feeding bottles and teats, which have never been covered by EU regulations with regards to marketing. When it comes to this statutory instrument, oppose improvement notices unless they are part of a process of law enforcement and breaches lead to sanctions, and update the guidance notes to reflect the new EU delegated acts. The vast majority still applies. Give these status so companies and enforcement officers treat them with respect. So thank you. It is now for Members of Parliament to act, and we ask voters around the country to contact their MPs and ask them to take this action that we are calling for. And I'll leave you with this final thought, that Brazilian breastfeeding rates recovered following implementation of the code in the 1980s, and other actions like those set out in the global strategy. If they can do it in Brazil, why can't we do it in the UK? Please do what you can to help mothers to breastfeed as long as they want to.